The broadcast is now starting. All attendees are in listen-only mode.
All right. Well, welcome to our seminar. Thank you so much for spending part of your day with us. This is Wolfsdorf Immigration Law Group. I am Sarah Baker, and I'm joined by my colleague, Jessica Marks. We're going to be presenting on immigrant visa options for scientists today, and this will cover 3 green card options for people seeking green cards to the United States. The first area we're going to look at is the Extraordinary Ability Immigrant Visa Petition. This is a first preference green card category, also known as EB11. We're also going to look at national interest waivers under the second preference. And we're going to be looking at one type of employer-sponsored green card category. That's the EB12, the first preference immigrant visa for outstanding researchers and professors. The focus of our webinar today, though, will really be on self-sponsored options for scientists seeking green cards in the United States. If you haven't had a chance to upload the PowerPoint already, you should have received a reminder email with instructions on accessing the PowerPoint. It should also be available on our website as well. We're going to ask that you hold questions for the end, and don't hesitate to email us any questions you have. Our email addresses will be displayed at the end of the presentation. I'm going to turn the presentation over to my colleague, Jessica Marks, and she's going to begin with talking about first preference employment-based immigrant visas for foreign nationals of extraordinary ability.
Thanks, Sarah. My name is Jessica Marks, and I'm going to start us off by talking about the EB11, known within the immigration community as the E11, E1A, or just EB1. And this is an immigrant visa category reserved for foreign nationals of extraordinary ability. And this is really for recipients of a one-time achievement that is defined as a major international award, or individuals who satisfy at least 3 out of 10 regulatory criteria evidencing that the applicant has risen to the very top of the field of endeavor. Now, that right there is the crux of the eligibility for this classification, and it is therefore very important to define your field at the very outset of your case. If you are claiming that you're at the very top of the field of a certain type of biomedical research, you want to say interventional cardiology as opposed to medicine in general. It's much easier to be a big fish in a small pond as opposed to a small fish in a big pond. Being a small fish in a big pond is not E11. This is a category for which you can self-petition, or an employer can sponsor you on their behalf in order to secure you as a permanent employee. There are some in the community that think that having an employer sponsor your case gives you a bit of an advantage. There's the idea that having a U.S. company already identify you as extraordinary and express the desire to secure your services on a permanent basis will give the immigration examiner to lean in your favor, but there are literally thousands of self-petitions that are filed every year, and they're approved, so not having an employer doesn't necessarily place you at a disadvantage. If you're already in O1 status, you may qualify for the EB1. The O1 is the non-immigrant corollary to the E11. It is also reserved for foreign nationals of extraordinary ability. However, even though many of those 10 criteria mentioned earlier also are relevant in the O1 context, the EB1 standard is actually much higher in practice. So there have been cases where someone who is apparently deemed to be at the top of their field in an O1 petition is not deemed at the top of their field in the EB1 context. The first step is establishing that at least 3 out of those 10 criteria are satisfied. And on the screen right now are the first 5 criteria. Now, let me mention that even though at a minimum the regulations only require 3, we generally recommend that you argue at least satisfaction of 4 or 5 criteria. And that's because the immigration examiner may disagree that the evidence that you've submitted satisfies 1 or 2 of the criteria, so you always want to have 1 or 2 extra criteria to fall back on. If you submit the petition just arguing the bare minimum of 3, if the immigration examiner does not agree with you on 1 of those, then you're knocked right out of eligibility. So let's start going through the criteria. The first listed there is lesser nationally or internationally recognized prizes or awards for excellence in the field, membership in associations that require outstanding achievements as judged by recognized experts in the field, published material about the applicant in professional or major trade publications or other major media about his or her work in the field, participation as a judge of the work of others in the same or an allied field, and original scientific contributions of major significance to the field. Now, before I switch over to the next slide, which lists the remaining 5 criteria, I wanted to point out that when you are assessing whether you have evidence or credentials that is going to satisfy any given criterion, you want to look at the language very carefully because, for example, if you look at the first 3, you'll see that they actually have several sub-elements. So in regards to prizes or awards, they have to be nationally or internationally recognized, and the prize or the award must have been given to you for demonstrated excellence in your field of endeavor. So when you're looking at a prize or award that you've received or published material about your work, you have to look and make sure, is it a prize that's nationally or internationally recognized? Is the published material about my work appearing in professional or major trade publications or some other major medium? If you are trying to argue that you meet one of these criterion, then you have to submit evidence that satisfies those sub-elements of the criterion. If you don't do that, then it's likely that the immigration examiner in charge of your case is going to issue a request for further evidence, and we'll talk about that later in the webinar. The following 5 criteria, the remaining 5 criteria, are now on the screen, and that is authorship of scholarly articles in the field, published in professional or major trade publications or other major media, display of the applicant's work in the field at artistic exhibitions or showcases, performance in a leading or critical role for organizations or establishments with distinguished reputations, commanding a high salary or other significantly high remuneration for services in relation to others in the field, and evidence of commercial success in the performing arts. Now, I think that I probably sufficiently terrorized everyone at this point. I've talked about how this is a classification reserved for individuals at the very top of the field who have, in some cases, won a major international award or achievement, such as a Pulitzer or a Nobel Prize or an Oscar. And I've talked about how these criterion actually have these sub-elements that make them seem quite daunting, and most of you are probably thinking, well, no one ever qualifies for this classification. I'm certainly not going to qualify. So much evidence is required. Now, the good news is that there is something called, in the regulations, a provision made for comparable evidence. And that means that the regulations specifically say that when the criteria, the 3 out of the 10, do not readily apply to the applicant's occupation, comparable evidence of extraordinary ability may be submitted to establish that you are indeed at the top of your field. You have enjoyed sustained national or international acclaim and recognition for your achievements. Now, the good news with scientists in particular is that several of the criteria, for example, evidence of success in the performing arts, do not apply to the sciences. So you should always argue comparable evidence. So, for example, scientists also can't argue display of work in artistic showcases. There's not many scientists and researchers whose work is going to appear in a museum. But comparable recognition for achievements would be presentation of a manuscript or an abstract or a poster at prestigious national and international conferences in your field. Invited and oral presentations are particularly persuasive because it indicates that you have been identified and singled out by these associations and organizations that provide leading forums for the discussion of original work in your field. So again, this is a very high standard. It is the kind of creme de la creme of all of the immigrant visa categories, but with scientists in particular, there is a way to establish that even if your accomplishments do not fit narrowly into those 10 regulatory criteria, you may nonetheless be able to establish that you are deserving of this immigration benefit. So those criteria, again, as mentioned before, are the first step in establishing your eligibility for an EB-1. Sarah is going to talk now about the second step, which is deemed the final merits determination.
Okay, thanks, Jessica. So we're going to look at the instance where you actually have your application in to the Immigration Service, and they are working on adjudicating your case. This final merits determination, second step in the adjudication process, all stems from a case. You may have heard the name Kazarian. It was a case of a person who filed a first preference extraordinary ability immigrant visa petition, and the case has gone up and down the court system. There was a decision in March of 2010, and the Immigration Service subsequently looked at this decision in the Kazarian case in March 2010 and drafted a policy memorandum that was issued in December 2010 purporting to implement the court's reasoning in this March 2010 Kazarian case. What the memo did was indicate that immigration officers who are reviewing certain types of green card cases will use a two-step process. And the types of cases where this two-step process applies are the extraordinary ability immigrant visa petitions that we've been talking about, outstanding professor or researcher immigrant visa petitions, which we'll talk about a few minutes from now in the PowerPoint, and also second preference cases for individuals of exceptional ability. Note that national interest waivers, which we're also going to discuss, do not fall under the purview of this policy memorandum. So in the first step, the officer is supposed to count the evidence presented. This goes back to the list of 10 regulatory criteria that Jessica was discussing a few minutes ago in detail. And the officer is going to see whether evidence has been provided for the regulatory criteria, which ones in particular, how many regulatory criteria the applicant is presenting evidence for. In the second step, the officer is going to make a determination under what they're calling the final merits determination if the evidence submitted is on the whole sufficient to meet the relevant legal standards. So in the case of EB-11s or extraordinary ability immigrant visas, you're looking at whether this individual, the applicant, has enjoyed sustained national or international claim and recognition for achievements in his or her field, and whether that person is really at the top of their field. So because of the second step in the adjudication process, the process of submitting and having these applications reviewed has become increasingly subjective. It's not really clear to anyone what exactly goes on under this final merits determination phase of review, except that the officer is making some kind of determination about whether the applicant has met the high standard for the immigrant visa category under which they are applying. And because of this increasing subjectivity, it's become harder for immigration practitioners to predict what the outcome will be in filing these extraordinary ability immigrant visa petitions. You might have a strong case that's filed that gets a request for evidence or even is denied, with the officer saying that the person just wasn't at the very top of your field. You might have a weaker case that goes through without any request for evidence. And what we've seen as well with this final merits determination is situations where the applicant presents 3 types of evidence under 3 categories or more, but the officer still comes back in this final merits determination and denies the case, saying, you know, it's all well and good that you presented evidence showing how you meet at least 3 criteria, but we still don't think that you have met the high standard required for the category under which you are applying. So whatever evidence you're going to submit and you're gathering for your case, make sure that it's all consistent with, in the case of an extraordinary ability immigrant visa petition, claiming that you have enjoyed sustained national or international claim and recognition for your achievements. That is the standard that you're looking to satisfy on the whole in this final merits determination. Some things to think about include, you know, look at the number of times you're claiming you've conducted peer review, or the number of articles that you've written, or the number of awards you've received during your career. If you only have one instance of reviewing or one publication or maybe one award, you might not have a strong enough case on the whole to get past the final merits determination phase in the officer's review of your immigrant visa petition. So we're going to turn to a few more issues specific to scientists that have to do with the final merits determination. Just as we were speaking about a minute ago, you want to look at the quality of the evidence that you're going to be putting forth. In the case of journal articles or publications, what's the rank and impact factor of those journals where you've published your work? The higher the rank of the journal or the higher the impact factor, the better argument you're going to have that all this evidence of your publications goes towards establishing that you meet the high standard for this type of immigrant visa petition. Also, you want to take into account the period over which you have published or presented or completed review activities. Again, for immigrant visa petitions for individuals of extraordinary ability, you have to show that you have sustained national or international claim, and this means over an extended period of time. As we were discussing just a few minutes ago, with review work, the more you've done, the more likely it is that you can separate yourself out from the pack and claim that you meet the high standard for your extraordinary ability immigrant visa petition. And for our purposes, student awards and scholarships are generally discounted completely. So here are some other issues to think about, especially for scientists when you're preparing your case and trying to prepare it with a mind to getting it through that second step in the adjudication process. If you're going to be arguing that you have a leading or critical role, think about what you're claiming. What is the project that you're working on? you want to show some kind of connection between the leading role or the critical role that you have on a project and how that project supports the mission of the institution that you're working for, or an agency that has an interest in the research that you're doing, or the grant that you're working on and in which you hold a critical role. You don't want to just show that you have a critical role on a small project. You want to link it up to that institution that you're working for. And without being able to make that link, the Immigration Service could come back and say, well, we just think it's fine and well that you have a critical role on this one project, but we're not convinced that it's really affecting the whole institution where you're working, or the agency that you have identified in your petition as being relevant to your work. Also, you want to get reference letters from top scientists in your field, of course, and they should have their own expertise in a relevant field, that's relevant to your work that you're doing. And the reference letters can help document a variety of the 10 criteria that Jessica was speaking about before. In particular, we like to have reference letters explain the original contributions of major significance that you've made to your field, and also they can be used to explain the critical and leading role that you play in terms of projects or your whole institution, as we were discussing just a few minutes ago. One thing to keep in mind with your referees, however, is you don't want to have referees necessarily who make you look bad. For example, maybe you're able to get a letter from somebody who has 500 publications in your field, and you only have maybe 35. You want to be careful about including that referee. Really think about it and make sure that you want to include that referee in your petition, because your application could be overshadowed by someone who has 500 publications when you have 35. So really think about that. Talk about it with your immigration attorney, how you can strategize in utilizing the reference letters. I'm just going to mention, if you have an interest in learning about the Kazarian case and this final merits determination, you can see some interesting blogs that we've written on our blog website. It's http://connect.wolfsdorf.com, and in the search box you can enter Kazarian, that's K-A-Z-A-R-I-A-N, and you can read over the information about the case, and also there are links to the government documents that are relevant to the final merits determination and the policy memorandum that I mentioned, which was issued in December 2010. All right, so now that we have discussed this final merits determination, we're going to move on to the actual process of filing your immigrant visa petition. It's really a two-step process. The first step is filing what I call the substantive portion of your case. This is where you're proving to the Immigration Service and arguing how you meet the standard required for whichever preference category or whichever type of immigrant visa category you're applying under. So you prepare your application, and you can either file the application online through the USCIS website, or there's a way to file the application in paper form as well. The second step is called adjustment of status or consular processing. This is what I like to call a more biographical portion or step of your green card application. The adjustment of status application is for individuals who will be processing this part of their green card from the United States. You have to be in the United States when you file for adjustment of status. If you know that you need to be abroad, for example, doing extended research, perhaps you're on leave somewhere else in the world, and you're going to be overseas, but you have an approval of your immigrant visa petition, you can request consular processing for the second step in your green card application. This would be processed through a U.S. embassy or consulate. If you file for adjustment of status, you're going to get 2 interim documents for travel and employment approximately 90 days after your adjustment of status application has been filed and receipted with the Citizenship and Immigration Services. Now the government is issuing what we call a combo card, where you receive a plastic card that has authorization for you for work and also can be used as a travel document. In the past, you received the plastic card, which was just the employment authorization, and a separate paper document, which was the travel document, but the Immigration Service has finally combined those into one document. Also, if you have spouses or children, minor children who are applying with you, they would file their adjustment of status application at the same time as you, the principal applicant. They would each be filing their own I-485 application, and they would also apply at the same time for their own travel and employment documents. You have the option to file the immigrant visa petition and the adjustment of status application together at the same time. This is called concurrent filing. One thing to keep in mind is that if for some reason your immigrant visa petition were denied, it forms the basis upon which you can file for and receive an approval on your adjustment of status application. So if the immigrant visa petition were denied, at some point the left hand of the Immigration Service working on your immigrant visa petition would link up with the right hand of the Immigration Service, and your adjustment of status application would also be denied, and you would be out the $1,070 application fee for your adjustment of status application. So you want to make sure to discuss timing issues and whether you should separately file or concurrently file your immigrant visa petition and adjustment with your immigration attorney. There is an option for premium processing of the immigrant visa petition. The filing fee is an additional $1,225. It's important to note there is no premium processing available for adjustment of status. Okay, so having talked about the process for applying for your green card, we're going to look at the Visa Bulletin, which is published every month by the U.S. Department of State. The Department of State is the agency that keeps track of how many immigrant visas are available each year, and every month they are updated. And you see that there are a limited number of visas available under each of the green card categories, employment-based green card categories, per fiscal year. So when you file your application, either your immigrant visa petition or if you're pursuing labor certification where your employer has tested the labor market to see if there are U.S. workers available, the date that you file that labor certification or your immigrant visa petition becomes what we call the priority date. And the priority date establishes your place in the line for the processing of your green card. So the Visa Bulletin that you see on your screen is available at that website that we have listed up there. It's a U.S. Department of State website. You can also just Google Visa Bulletin and whichever month you want to see in the year, and you'll be able to find the Visa Bulletin easily. You can see dates up there under China, India, and then for the third preference, all across the board. Those are cutoff dates that the Department of State updates every month. You're seeing here the April Visa Bulletin, which is showing cutoff dates for China and India in particular under the second preference employment-based green card category. So what is this cutoff date? Well, whenever the total number of qualified applicants in a particular employment-based green card category exceeds the number of immigrant visas available for each month, then we say that that particular category is oversubscribed and a cutoff date is established. So there you see, if you're from China and you're filing a second preference green card, the cutoff date there for the April visa bulletin is May 1st, 2010. Only applicants who have a priority date that's earlier than the cutoff date listed can apply for adjustment of status. So again, if you don't have a case that's already pending or your case was not filed before May 1st, 2010, then the Immigration Service would not be able to work on your adjustment of status application, or you would not be able to file your adjustment of status application. One thing to note is that the May visa bulletin has already been issued, and the cutoff date that they're showing for second preference employment-based green card applications for Chinese and Indian nationals is August 15th, 2007. So there's been a further retrogression or backlog of cases filed under the second preference for Chinese and Indian nationals due to the fact that there's a higher demand for that particular immigrant visa category than there are number of immigrant visas available. You can find the May visa bulletin online as well. All right. So I'm going to turn the PowerPoint over to my colleague Jessica, who's going to start us off talking about national interest waivers, which are a second preference green card category.
Thank you, Sarah. So as Sarah mentioned, the National Interest Waiver, NIW, is an employment-based second preference category, meaning that for those who are coming from a country, were born in a country that is oversubscribed, there's not going to be the option of concurrently filing the I-140 and the adjustment. You're going to have to wait for that priority date to become current. And we'll talk about that in a little bit, but for now, let's just get started with the regulatory and statutory standard. How does one establish that he or she is eligible for an NIW? Just to mention, this is also a self-petition. There is no requirement that an employer be sponsoring you for a permanent position. Now, with the NIW, the question is, what are we asking to be waived? Well, first and foremost, it's the job offer requirement. That's why it's a self-petition. But also it is the labor certification process, as Sarah mentioned, which involves an employer testing the labor market, determining whether there are qualified, willing, available, and able U.S. workers for the position that is being offered to you. So that is relevant to this three-prong test that you see on the screen. The third prong being the one where the real heart of the NIW is. The first is that you must establish that your work has substantial intrinsic merit. The second prong is that your work is national in scope. And the third is establishing that the national interests of the United States would be adversely affected if the labor certification requirement were not waived in your case. So what does that mean? How does one establish that? It seems like a very nebulous standard. So let's get into some guidance on what is important when applying for an NIW and how to satisfy that third prong. Now, like the final merits determination in the Kazarian case, there is a famous case in the NIW context called NIWs, which stands for New York State Department of Transportation. And in that case, the court said that the third prong means demonstrating that the applicant has had some degree of influence on the field, some impact on the field as a whole. So when we look at the first two prongs, work being of substantial substantial intrinsic merit, it being national in scope. For many scientists, that's not going to be an issue, especially those who are doing work with quite significant and obvious practical implications. So biomedical research relating to drug discovery, and that's not to say that if you are doing some kind of deep physics research, something that doesn't necessarily have practical implications or applications that are going to be saving lives, that doesn't mean that your case is not going to be successful. It just means that the benefit of your work may not be as glaringly obvious or apparent to the examiner. Now, that third prong really forces us to look at you, the applicant, as an individual, as opposed to the work that you're doing, which is relevant for the first two prongs. So just simply arguing that your work is so important that any person who's engaged in that area of research or science should receive an NIW is not going to be successful. It's about you as an individual establishing that you've had some degree of influence on the field. So this is obviously a lower standard than the extraordinary ability immigrant visa category, because we don't have to prove that you're at the top of the field. We don't have to prove that you're one of that small percentage. You don't need to establish sustained international or national acclaim. But nonetheless, many of those regulatory criteria are still going to be relevant. We're still going to look at your publication record, any review work that you've done, any committees that you participated in, your original contributions, the organizations that you've worked for. Those are all still going to be very important credentials to assess. And again, you don't have to really focus as much on comparing yourself to others in the field, establishing that you are so much more qualified or at such a high level, but you still must establish to some extent that you have distinguished yourself and impacted your field. So some issues specific to scientists. We talked about publications. First author is a very strong factor. The lower that your name appears in the list of co-authors on a published paper, the more difficult it becomes to attribute any impact that research has had on the field directly to you as the scientist, as the applicant. Now, that's not to say that if you have no first author publications, you're not going to be able to get an NIW. This is really like a big picture type of approach, kind of like the final merits determination, even though that's not really applied in the NIW context. We're looking at all of the evidence as a whole to establish whether it paints the picture of someone who has influenced their field. So don't worry too much about these individual things. If you don't have any first author, or if you only have a handful, one thing that can be really useful to kind of address that weakness in the case is the reference letters. So even if you don't appear until maybe the third or fourth name in a publication, if one of your collaborators and co-authors can issue a statement confirming that your contributions were critical, that you nonetheless were in a leading role in some capacity in the research project, that can overcome, like I said, this kind of slight weakness in your credentials. A limited publication record, if you don't have very many published papers, can also be overcome by a high citation record. So when we're looking at all of these factors, all of these considerations, a lot of people ask, well, what's the magic number? How many papers do I have to have? How many citations do I have to have? How many first author is good enough? And there's really no magic number. There's no threshold above which you're going to be safe. There's no threshold really below which you're going to be fatal. If you only have 3 or 4 publications, but cumulatively they have more than 400 citations, then that may be sufficient to secure an NIW. Whereas someone with 30 publications and only 15 citations, the Immigration Service may say, well, there's no evidence that this work has influenced the field, which again is the crux of that third prong for the NIW. Now, kind of a relevant consideration to the publication and the first author issue is the fact that many of you at even preeminent institutions are going to be working in very large collaborations. So again, there may be 50 or 60 co-authors on every paper that you've published. So the larger the group in which you've been working, the less willing Citizenship and Immigration Services may be to credit you with the contribution to the field. And again, reference letters are important evidence of your critical role in a project. So you can see that there are some scientific collaborations that have dozens or even hundreds of people involved. It's really important to strategize and to discuss with your attorney how you are able to demonstrate that your contributions to that huge collaboration have been significant, have garnered you recognition in the field, and have had influence on the field. The NIW processing is very similar to the EB-1, but again, there are employment-based second preference backlogs for applicants who are born in China and India, and one difference is that there's no premium processing available for NIWs. Currently, NIWs, at least at the Texas Service Center, one of the 2 service centers that processes them, is taking approximately 4 to 5 months. So it's not too long to wait, but you can't get that 15-day adjudication with the extra premium processing fee. One thing that we often suggest, or at least an option we like to review with our Chinese and Indian-born clients, is filing an NIW to establish that priority date, to establish the place in the green card waiting line, and then trying to build up the case toward an E-11, which for the past several months, and I believe maybe even years, has never been retrogressed for anyone, not even Chinese and Indian born, except for maybe 1 or 2 months out of the fiscal year. So that doesn't mean that there's necessarily going to be tremendous steps that you can take to build up the E-11 case. There's only so much that you can do. You know, you don't really have control over who's citing your work, but you can definitely start accepting some of those requests that you've received to sit on a committee for a conference or to do peer review work. I know a lot of people are very busy and they don't necessarily make the time for that, but that would potentially secure at least one of the E-11 criteria, being the judge of the work of others. So there are some active steps that you can take to start building up a better E-11 case. And in the meantime, if you were born in China or India, you will have established a priority date with that NIW. So now Sarah is going to talk with us about our one and only employer-required sponsorship immigrant visa petition, and that is the employment-based first preference second category EB-12 outstanding researcher or professor.
Thank you, Jessica. So as Jessica said, this is an employer-sponsored type of immigrant visa petition, and the employers who are eligible to act as sponsors are universities or institutes of higher learning and private industry firms. With private industry firms, there are 2 added sub-requirements. The company must employ at least 3 researchers full-time, and the company must have documented achievements in the academic field that you're claiming you are an outstanding researcher or professor in. And I think all of this has to do with showing that you are going to have a long-term position with this private entity, and that it's a legitimate private entity who's already got some achievements under its belt. Also, you must show that you have at least 3 years of experience in teaching and/or research in the relevant academic field. If you're going to try to argue that research completed towards your advanced degree should be counted at that time when you were conducting research toward your studies, you must be able to show that that research itself has been deemed outstanding in your field, or if you were teaching while you were working on your advanced degree, you must be able to show that you had full responsibility for the classes you were teaching. The position offered to you from that university or private industry firm must be permanent, tenured, or tenure track. So for teaching positions, it's pretty easy to understand what tenured or tenure track means. You would need to just check with your institution if that is the type of job that they're offering to you as a professor. In terms of research, the Immigration Service has let us know what they consider to be a permanent position for researchers. It's one where the individual has an expectation of continued employment and where the position is of an indefinite or unlimited duration. For those of you out there who may be working under grants, you don't need to necessarily be concerned that your position can never be considered a permanent research position. What the Immigration Service will look at in terms of grant-funded positions and their longevity is the tendency of the sponsoring institution to continue to request renewals of the grants and the continuing availability of funds to fund that research position. The standard for the EB-12 is showing that you're recognized internationally as outstanding in your academic field. And the Immigration Service has let us know what they consider to be an academic field. It's a body of specialized knowledge that's offered for study at an accredited U.S. university or institution of higher education. Next, we're going to look at the criteria for the outstanding researcher or professor petition. You want to show that you meet at least 2 out of 6 of the regulatory criteria. And these include awards, memberships, published material in professional publications. And I'll just go through these first 3 in more detail before turning to the next slide, which lists the remaining 3 criteria. For awards and prizes, you want to show that they're major, they have some sort of weight in your field. They also need to be for outstanding achievement. That's not to say that a specific criterion of the award being granted is outstanding achievement, but you want to show that there's some kind of recognition of a contribution or a professional achievement that you've made that forms the basis of receiving the award. For memberships, it's similar to the EB-11 category. You have to show that the membership requires outstanding achievements in order to join. This is not a membership where you just pay dues and become a member of the relevant organization. The Immigration Service is really looking for something more. They want to see that there's a thorough evaluation process conducted in deciding whether or not you should become a member of this relevant association. For publications about your work, they need to be relevant to your work. They need to discuss your work. This can be things like internet articles about your work. Maybe your presentation has been profiled for a conference media page that was published on the internet. Maybe there are professional articles or scholarly articles that discuss your work in the body of the article itself rather than just as a footnote for academic honesty. Turning to the next 3 criteria, You can also show that you've judged the work of others in your field, and again, it needs to be either your precise academic field or a related academic field. You can also show that you've made original scientific or scholarly research contributions. This is often best shown through reference letters that we talked about before in the presentation, where the referees are attesting to your contributions and the achievements that you've made in your scientific research and how those achievements have been recognized by the rest of the field. And lastly, you can prove that you're an outstanding researcher or professor by arguing you have authored scholarly books or articles, and they need to be in books or journals that have international circulation in your relevant academic field. So this final merits determination, the second step in the adjudication process that was implemented by the policy memo from the Immigration Service in December 2010 and stemming from that Kazarian decision, also applies to outstanding professor or researcher EB-12 petitions. And here, what they're looking at in the final merits determination is whether all of the evidence taken as a whole together shows that you're someone who's internationally recognized as outstanding in your field. The next topic that we're going to discuss, and really it's going to be the last specific topic that we're going to discuss before we conclude the webinar, is request for evidence. What is a request for evidence, or RFE? This is an instance where you filed your immigrant visa petition with the Immigration Service, and they come back with a letter, usually sent in the mail, asking for additional information or evidence or explanation of your qualifications for the particular immigrant visa that you're claiming for the basis of your green card. These RFEs are not uncommon with extraordinary ability EB-11s or the NIWs. They're less common with the outstanding professor or researcher immigrant visa petitions. I think this is because, in part, the NIWs in particular tend to be more complex cases where the Immigration Service really has to get in there, get their hands dirty, and try to understand what research it is you're doing that's in the national interest of the United States. Make sure if you do receive an RFE that you read it very carefully. These documents often contain inaccurate statements of fact, or they totally disregard some facts or evidence that you submitted for a particular regulatory criterion. Sometimes they can contain inaccurate statements of the law. That's why it's always a good idea to get an attorney involved if you filed your petition on your own initially to help you with the RFE response so they can identify these inaccurate statements of law. For example, sometimes Immigration Service applies the wrong standard to the immigrant visa category that you're claiming. Also, you want to try to get behind the RFE. Read between the lines. What is it that the officer is really asking for? Is there something about the petition as a whole that they are just not buying and you could provide evidence for to help set aside their concerns? Really look at that RFE and try to put yourself in the mind of an adjudicator who is not familiar with your field and try to figure out what they're asking for in particular. Jessica is going to discuss the last 2 points regarding requests for evidence, and then we're going to head into our question and answer session.
Thank you, Sarah. So yeah, just to kind of dovetail into what Sarah was just saying, don't assume that the officer did his job. A lot of the time when an applicant gets an RFE and sees that it's 4 or 5 pages long, complaining about the quality of evidence, or saying that no evidence was submitted in support of the majority of the regulatory criteria, the applicant thinks, oh, what did I do? I thought I submitted really good evidence. Now they're saying I don't have anything. I must have done something wrong. Don't assume that the officer really closely and carefully analyzed all of the documentation that you filed in support of your petition. These petitions are oftentimes 3 to 4 inches thick. The officer who's going to be looking at your case is also reviewing maybe a dozen or more similar petitions on a daily basis, and a lot of the time they are not necessarily going to be able to spend the time that they should with each case and going through all 400 pages of documentation. So if you submitted evidence that you performed in a lead or critical role for an organization with a distinguished reputation in the form of a single reference letter or information from a website about your role with an organization, and then you see an RFE indicating no evidence was supported in support of that criterion, then you know that the officer was mistaken. You can sometimes just repackage your application with a cover letter or a brief explaining that, yes, in fact, there was evidence submitted in support of a certain regulatory criterion, and that the officer is mistaken in believing that that evidence does not satisfy that criterion. A common complaint we see in RFEs is that the applicant is relying solely or primarily on the reference letters to establish original contribution or influence on the field. And that's where the content of the letters becomes absolutely crucial, because the reference letters are not just those very basic kinds that confirm that you hold such and such position, you received your PhD from so-and-so institution, and that you have this grade point average, or you finished third in your class. It's not just a litany of the highlights from your CV. They need to be detailed, specific discussions of what you have done and why it's important. And most importantly, the brief, the cover letter that accompanies the petition needs to explain how all of the other evidence, your publications, your presentations, corroborate the assertion in the letter that confirms you are at the very top of your field, or you've had some influence on the field, or that you're internationally recognized as outstanding. So the fact that you have had publications in very high impact or ranking journals, presentations in leading venues, that in and of itself is evidence of international recognition as being outstanding, influence on the field, because generally journals and organizations of a certain caliber are not going to publish or present your work unless it is original, of major significance, or has had some degree of influence on the field. So the reference letters are really supposed to tie all of those pieces together, and in an RFE response, if the officer is complaining you don't really have any original contributions, you're just putting in reference letters that are solicited from your friends and colleagues, in any response to the RFE, point out that there is substantial other evidence that corroborates those reference letters, and the reference letters are not being relied upon solely to establish satisfaction of that criterion or criteria. So that concludes our presentation, the substantive portion, and we are now going to open the floor to question and answer. We already have some questions online that have been submitted by the audience. If you don't feel comfortable sharing your question, or it's too fact-specific, please feel free to send us an email. Our contact information is right there, or you could reach us at 1-800-VISA-LAW. That is our phone number. And when you speak to the receptionist, just advise that you listen to the scientist webinar, and that you had a question about your specific case. So I'll go ahead and take the first question here. Someone in the audience has asked, Can a J1 student apply for an EB-1-2 without the home country rule waiver? So I'm assuming that's coming from someone who is on a J1 and is subject to the 2-year home residence requirement, meaning that he or she must obtain a waiver of that requirement before applying for an H visa, an L visa, or permanent residence. So the answer to that, can you apply for an EB-1-2 without a waiver, is yes, because the EB-1-2 is a form of immigrant visa petition. It is not actually an application for permanent residence. So that means that not having the waiver does not bar you from filing that EB-1-2, but you cannot then file the I-485 without that waiver because that's the application for permanent residence. So you can complete the first step toward the green card, but you can't ever take that second step, the permanent residence, until the waiver is secured.
I would just add to that also, Jessica, that one thing you want to think about is if you are on a J1 right now, it's probably fair to say that you are towards the beginning of your career. So you need to keep in mind the elements that are required for that EB-1-2 petition. You have to have an offer for permanent employment from the sponsoring employer, and you need to be able to show that you have at least 3 years of experience in your academic field. Usually we count from the awarding of the PhD degree, or if you're a physician researcher, from your medical degree. Often people who just recently received their PhDs or advanced degrees, in the case of a physician scientist, aren't quite yet at the point in their careers where they can really show that they're outstanding and internationally recognized in your field. So you want to think about the timing of the application as well when you're considering which green card category to apply under.
An exception to that may be someone who has a relatively well-established career in their home country, completed their doctoral studies or their residency or fellowship training, and then worked for a few years in a professional position, and then came to the U.S. to continue their training. I have seen cases, E-1-1s in particular, successful for physician who had a professor position in his home country, came to the U.S. to do a fellowship in a subspecialty of medicine that was not available in the home country, and was very soon after finishing the training in J1 status able to secure an E-1-1. But Sarah's absolutely correct. It's really important to look where you are in your career, what your current status is. All of those factors come into play when strategizing. And that is very closely related to one of the other questions that we've received, which is if the EB-1-2 case fails and the applicant is in their optional practical training after completing their F1 studies, would they lose their status? Generally, filing an immigrant visa petition that is unsuccessful is unlikely to result in a termination of F1 status. It may be difficult to secure an F1 visa if you're going to be traveling abroad, because you have to disclose that you filed that petition, and that is evidence of immigrant intent, which you are not allowed to have as an F1 student. If you're on your OPT and the I-140 and the 485 green card application are filed concurrently and denied, in that case, the Immigration Service could say you have filed a green card application, you clearly have the intent to immigrate to the United States, and you are therefore no longer a valid F1. We've seen that happen in some cases. It doesn't always happen, but again, that just underscores what we've been talking about in terms of really making sure that you apply for the correct category at a time in your career and in your immigration history that makes sense. So Sarah, we have some questions about the filing fees and the legal fees for the different applications. Would you like to go into some detail about that?
Sure. So I will start out with the legal fees. This is really something that we would need to assess your case first on before we could quote you a fee. So please reach out to us. Feel free to email us, and we're going to ask for your CV and also perhaps information on your achievements and detailed information about where you are in your career. In terms of the government filing fees, the fee for the immigrant visa petition is $580. And as I mentioned, you can file paper or electronic. Electronic, you're putting in a credit card on the USCIS website, and then there are certain steps you have to file to mail in the paper documentation afterwards. The filing fee for premium processing for the categories that allow premium processing for immigrant visa petitions is $1,225. That's in addition to the regular filing fee of $580. And then the filing fee for adjustment of status is $1,070. That's $1,070 per applicant. Children who are under 14 are subject to a lower filing fee, which is in the range of $600.
So we have one question about the judge of the work of others criterion, saying if you reviewed a paper in a journal for your boss, does that count? Well, yes, it counts in really the most literal and basic sense because you have indeed reviewed the work of others. However, that is not necessarily indicative of being recognized internationally as outstanding or for having influence on the field or for being at the very top of your field. So any evidence that you submit to support a particular criterion or that you're using in the NIW context to prove that you've had some degree of influence on the field, just because it meets the kind of bare minimum literal requirement of the regulation doesn't necessarily mean that you should submit it, because if in that case, if it's just your principal investigator or your thesis advisor who received a request to review a manuscript and then they turned around and said, hey, could you look at this for me? Yes, again, that meets the literal language of the criterion, but immigration could actually use that against you and say, that doesn't indicate anything about your standing in the field or your achievements or your recognition for those achievements. That's just you helping out your boss.
Yeah, and I would add to that, too, that if you look through the policy memorandum that I spoke about, the Immigration Service actually lays out examples of the different types of evidence or pieces of evidence that they would accept and that they, I guess, would want to see for the various regulatory criteria. And in the case of judging the work of others, in the past, they hadn't been so strict about this, but now they're wanting to see things like not just a copy of the email where you were asked to review, but also the return email where you either were saying, yes, I'll do it, or an email sent back to the journal attaching your review. So they really want detailed evidence that the accomplishment can be attributed to you personally.
So we have a question about the EB-12. Sarah, have you ever seen postdocs filing under that category?
Postdocs. This question comes up a lot. Again, you have to look back at what the requirements are. A postdoc position, by its very nature, is not one that the Immigration Service is going to consider permanent or a permanent offer of employment, because postdocs, while they can go on for a while, tend to be limited in duration. So you would need to move into a position that is considered permanent. If it's a teaching position, then it's got to be tenured or tenure track. And if it's a research position, then it's got to be one that's either an equivalent to tenured or tenure track, or a position that is of unlimited duration and one in which you can have an expectation of continued employment. So the short answer there is if you're applying on the basis of a postdoc position, that would not work because it's not considered an offer of permanent employment.
Yeah, the best option for postdocs is generally going to be the NIW. As I said, there may be some situations in which someone who's a postdoc could apply for an E-11 if they've had a more established career in their home country. The same is true for physicians who are in their training or have recently finished their training. But generally, the NIW, which of all of the categories we've discussed today is the lowest standard, is going to be the best option for postdocs. So we had one question that applies to all of the categories we've discussed, and that is, how long should the letters of reference be? And as with most of the things that we've discussed, the criterion, there is no magic number, but I think it would be difficult to demonstrate in a letter that someone has made an original contribution or has had some impact on the field in less than 2 pages, because the first or the first 2 paragraphs of the reference letter is going to consist of the referee discussing his or her own credentials to assess the applicant's standing in the field and the contributions that they've made to that field. So you don't want a reference letter that is at 60 or 70% the referee just talking about him or herself. The bulk of it needs to be a discussion of the applicant's work. And that goes also for how many referees you should have. It's really about quality, not about quantity. So having 15 letters that are redundant or vague or just very briefly touch on your accomplishments and what you've done in the field is not going to be as persuasive as having 4 or 5 letters that go into a great amount of detail about what you have accomplished, how you accomplished it, and the recognition that you've received for those accomplishments in your field.
I would also add for reference letters, when you're thinking about who's going to serve as a referee or where the letters are coming from, keep in mind the standard, the relevant standard for whichever category of green card you're applying under. For example, with outstanding professors or researchers, EB-1-2, we know that you need to show you're recognized internationally in your field as outstanding. So it's a good idea to have several letters from referees who are working outside the United States. And yes, Canada is considered an international source of reference letters, despite what some folks might think.
Sarah says that as a Canadian.
That's right. That's right. And again, you know, for EB-11, think about that standard. If you're arguing that you're nationally acclaimed in your field, then it would be appropriate to have letters from within the United States. Or if you previously only worked in one country, you know, you might have some letters from your home country. Or if you're claiming you're internationally acclaimed, then make sure you have a selection of letters from people working in different countries. And all this helps to make that argument that you're meeting the relevant standard for the category you're applying under.
So a follow-up question to that, Sarah, that we just received is, should the majority of the reference letters be from people who don't personally know you or have worked with you? What's your opinion on that?
So I'm of the opinion that a mix of both is okay, and different practitioners have different opinions about this. Sometimes the Immigration Service will say, you know, if you only provide letters from people who are at arm's length from you, have not worked from you, they'll say things like, well, clearly you were just soliciting letters for the purposes of the application. You know, how is it that these people have adequate knowledge to discuss your achievements? Versus the Immigration Service saying things like, well, these letters are biased because they are only coming from people that you've worked with and they're really close to you. So I think sort of a smattering of both types of letters is good. Things that you want to watch for, though, in particular, it's probably not ideal to have letters from, for example, everyone who was on your PhD review committee, because those people will be really, really close to you, and again, a possibility of having the Immigration Service saying that those letters are simply biased. Sometimes what helps too is to ask your supervisor or your principal investigator if they know contacts that they could reach out to help with getting reference letters for your petition. Do you have any thoughts on that too, Jessica?
Yeah, again, every practitioner, even within a single firm, may have a different opinion on this. I personally feel comfortable with at least 1/3 of the letters coming from individuals who have never collaborated with you directly or who have never been at an institution at which you have studied or trained. Anything less than that, unless there is really substantial evidence in the form of the publications or citations, the type of evidence that's going to satisfy all of the other criteria, you're just going to see that language in the RFE that Sarah just mentioned about you soliciting letters, and therefore none of them constitute persuasive evidence. And in regards to, seeking out letters from individuals who you don't personally know, like Sarah said, asking your mentor, your PI, or supervisor is a good way. And oftentimes I also suggest to people, reaching out to leaders in the field that have discussed your work with you at a conference. If you've given a poster presentation or an oral presentation, someone's come up to you afterwards and said, hey, that's really interesting. It directly applies to my work. Let's talk about everything, that is kind of, at the cross sections of both of our research. That person can be a good person to ask. If you have noticed, I don't know if anyone has this much time, but if you've noticed in the citations to your work, one person or one department at a particular institution citing to your work frequently, that may be a good place to also look for an independent referee. So these are all things that are, again, quite fact-specific, but we're more than happy to work with you to brainstorm on how to secure the necessary number of reference letters, the quality, and the sources that are going to work best for your case. Someone has asked, employees from institutions such as NIH and NASA cannot write on official letterhead. Are they still counted if they're just writing, for example, on their personal letterhead? That's actually not true. We do use referees from NIH quite frequently, and they can write on their letterhead. It could be a department policy, or that particular individual may not feel comfortable because they think that that is reflected as an official government endorsement. But yes, it still counts even if it's not on the official institute's letterhead. That's not necessarily problematic as long as there is another way to establish that the person is at that institution, for example, just printing out their profile from the institution's webpage. So Sarah, we have another question about the timing of applying. Can I apply for an NIW while I'm on my OPT?
You can. Again, as Jessica raised the issue, you want to think about what's going to happen to your underlying student status. If your case were denied and you were trying to continue on as a student, you want to think about whether there's the potential that the Immigration Service would say, well, you no longer have non-immigrant intent or intent to remain only temporarily in the United States. We're not going to let you continue on in your F1 status. I mean, it is a possibility, and we always recommend to people that they maintain an underlying status while their green card is being processed, in case something unanticipated happens with either their immigrant visa petition or their adjustment of status application if they're applying from within the United States. One thing to note is that H-1Bs are not subject to the same rules about not having not having immigrant intent. They're a dual intent visa, so you can have the intention to come on an H-1B for up to 6 years of time, while also intending to apply for a green card. So you might put yourself in a better position if you're able to get on an H-1B and then start looking at your green card options. But all of this is really fact specific. It would depend on the particular individual and what their situation is as well.
So it looks like we're running a little over time. I'm going to answer one more question. We apologize if we didn't get to your question. Please feel free to email us, and we'll be happy to provide you with any information or an assessment of your case if you need. So the last question we have is asking about evidence that your article has been accepted for publication and is forthcoming but is not yet in print at the time that you apply. Now, that depends on if it's all of your articles or just some, because if you look at the language of the regulatory criteria for the E11 and the E12, it says authorship of scholarly articles published in professional or major trade publications or other major media, or articles published in journals with international circulation or books. So the published indicates past tense. The E12 actually just says authorship. So maybe you could make that argument if it's only some of your articles, but if nothing has been published, then we would probably say that it's not quite ripe. But again, that depends on the individual merits of the case. There may be other factors that make it strong enough to nonetheless file at the time that the articles aren't yet in print. And even if a request for evidence is issued, we can still argue that it was accepted at the time of filing and was subsequently published and is still indicative of the person having enjoyed sustained acclaim or a reputation for being internationally outstanding. So thank you again for calling in today and sharing your afternoon with us. We hope that this was useful. And again, apologies if we did not get to your question. We'll be happy to communicate with you via email.
Thank you.